Non-compete ban lawsuits and maybe the ultimate corporate cringe. What do they have to do with each other? Watch till the end. And don't worry, this won't be that long. So, some background. About 2 weeks ago, the U.S. Federal Trade Commission, or FTC, issued its final rule effectively banning non-competes in the U.S. It's scheduled to take effect September 4th. But already 3 lawsuits have been filed. Now, in videos, I've talked a lot about 2 of those. Both of those are in Texas. Both of those have been further along. One even had a whole scheduling order. But at the very end of the day last Friday, the judge in that case said, nope, we'll go ahead and let the other case, we'll defer to them. And that case is filed by Ryan LLC, which is a really large tax advisory firm that has employees in all sorts of states across the US. So a big tax advisory firm. So that's one of the businesses that is filing suit against the FTC, saying, hey, we need non-competes and that this ban should not go forward. But what about the other case? So that one was filed in Pennsylvania, and that was filed by ATS Tree Service. Now, this is kind of interesting to me anyway, and I think some of you, because Ryan LLC, which is the business in Texas, that's like a big nationwide tax advisory, the other organizations that had filed the lawsuit that's now on hold was like the U.S. Chamber of Commerce, Business Roundtable, these pretty large groups representing a bunch of employers. But the business in Pennsylvania that's by itself suing the FTC to seek to strike down the non-compete rule is a little bit unique. This is ATS Tree Services, LLC. They describe themselves as a 10-year-old business that was started by an individual founder and has expanded to only have 12 individual. ATS describes itself as founded by one guy in 2014, that they've grown to be still a relatively small business, but employ 12 individuals, that they care for trees in residential, commercial, other properties in specifically Bucks County, Pennsylvania. Now, so why would they be challenging the non-compete ban? Because ATS says in its filing that they make every one of their employees, all 12 of them, sign a reasonable non-compete agreement. That includes that they won't work for a competitive business for 1 year following termination of employment within the area that they provided services, so ostensibly this area of Pennsylvania. And they say, hey, when people come aboard, that we provide them extensive training. We have apprenticeship programs. We consider our new hires for like crew, lead positions. We provide all this investment, and it's really specialized knowledge in tree climbing. And so if we didn't have these non-competes, then our employees could go out and immediately take that and work for a competitive business. So all of our investment dollars will have gone bye-bye. Now, what stuck out to me, aside from just the general issue of these non-competes, which we'll talk about, was a line from paragraph 83 of their initial filing. ATS considers its employees a part of the ATS family. It is on their website as well. Now, on the HR Besties podcast, which I co-host, we've used the term "we're like family" as a corporate cringe, because in an employment context, it is an employment relationship. But unlike family, I don't know if Thanksgiving dinner has a prohibition on somebody else leaving and going to a competitive Thanksgiving dinner for another family for a year. And yes, I know some people would love to have that. But point is, in an employment relationship, things like that, like we're a family, a non-compete kind of goes against that, in my personal opinion, in that it is an agreement that someone can offer to an employee, but it's not necessarily consistent with an employer-employee relationship. And in my experience, I've generally recommended organizations that have non-competes be really careful about who those are offered to, because offering those or requiring those across the board from every employee, depending on their role, tends to discount whether they're necessarily required and specifically targeted for each role. And I haven't seen the actual non-compete language of the ATS, but just something I'll be mindful of in watching the suit. Now, why I haven't focused on this ATS lawsuit as much is because I'd said the 2 Texas cases, which were just filed like a couple days before this one, but they've gone a lot further. And those also were from organizations that are more nationwide. The one in Pennsylvania is a bit different because it seems like this company only operates within Pennsylvania. And so if they're, for example, requesting that the judge strike down the non-compete ban nationwide, it's a little harder for them to make that argument for all employers when they only have a small company operating within a small business. But speaking of the judge, I've talked about how important the judge deciding the case can be, and how often the group that's filing the suit probably has judges that it would like to have. In Texas, both of the judges that were over those cases were appointed by President Trump. And so, again, it's never a guarantee, but often those parties probably expect that a judge appointed by President Trump would be more likely to rule for those business groups, so those groups suing the FTC. But here, The judge in the Pennsylvania case is Judge Kelly Brisbane Hodge. Now, Judge Hodge only took the bench within the last couple years. She was actually appointed by President Biden. And so for the FTC, that may seem like favorable. Like, okay, this, the FTC is on President Biden's FTC, so maybe she'll be more likely, they may think, to uphold the ban in court. And again, it's never a guarantee because, for example, the FLSA salary increase rule, which is, I've done separate videos, that's going on. No lawsuit yet filed at the time I'm recording this on that. But in 2016, that rule was struck down by a judge who had actually been appointed by President Obama. So again, you never know. And notably, Judge Hodge, she has a really interesting career, included some public defender work, but the couple years before she took the bench, she was actually a partner at Fox Rothschild, which is a large law firm in Pennsylvania that tends to represent employers. So her experience before she took the bench, I did quickly look and I looked through her congressional testimony and I didn't see anything specific on non-competes, but overall, she likely is very familiar with the type of arguments that ATS Tree Services and other employers are making regarding non-competes and upholding those. So anyway, interesting that even though she was appointed by President Biden, she has most recently represented employers in employment-related litigation. Also notably, the law firm that's representing ATS Tree Services is Pacific Legal Foundation. Now, I took a quick look at their website and just thought it was interesting. Because I don't know if I'd ever seen, I think this is UFC, fighting on a law firm website. But anyway, a little different. But so this case is also underway. And so both in the Texas case, which is the Ryan LLC, and this Pennsylvania case, ATS Tree Services, both are seeking bans on non-competes. Explicitly in the Ryan case in Texas, they've asked for a nationwide injunction against non-competes so that it wouldn't just apply in Texas, it would apply across the whole country if the court were to say, we're at least temporarily not going to enforce this. In Pennsylvania, in looking at it, I did a quick search and did not see nationwide, but ostensibly they're seeking for a ban as well. But how does this work? Could there be two different decisions? Now, that's part of the reason why in Texas, one of the courts, that U.S. Chamber of Commerce's suit, why that judge is like, we'll just let this other Texas case go ahead, because courts really don't want that. You don't want to have two different conflicting injunctions happening, like where one court could say, we're striking down this ban, and then another court say like, no, it's good, go ahead. And what happens in that instance is you have to quickly appeal to the courts of appeal, but ultimately the Supreme Court, that's the U.S. Supreme Court, what their role often is to resolve what's called conflicts. And so while it is possible that the judges could have two rulings, I wouldn't personally, again, don't know anybody involved, but wouldn't personally be surprised if even because the Texas courts have already kind of gone ahead, if in Pennsylvania, since not as much has happened, there's no scheduling order yet, if for some reason that case doesn't go on ahead. But we'll see. I'll be watching it. But overall, it's interesting to see how, one of these lawsuits is filed by a huge company that has people all over, the more of the corporate non-competes you might think of. But the other is one of the examples that the FTC in its rule, and it's like hundreds of pages long, it's kind of explanation of the rule. And it talks about non-competes, they'd gotten a public comment from, I believe, the CFO of ATS Tree Services, but had been against this non-compete ban. But in the FTC's rule, they talk about non-competes being used by so many industries. They're super critical of food, retail and food and retail businesses because Jimmy John's had non-competes for its frontline employees. The FTC did not care for that very much and dealt with that a few years back. So they referenced that in their rule. But this kind of 12, small business making all 12 employees sign non-competes. This is really similar to the things the FTC was critical of in their rule. So it'll be interesting to see their briefing and if that differs in any way, if this case, does kind of go forward and there's all the legal documents back and forth from the Ryan LLC, which is the more corporate environment. But people had asked about it. Again, I'm not a wizard, but I do, read through these things. I look at the docket. I do due diligence, and so I try to break them down. But seeing the ATS Tree Services, we're like family of the people that have all of their employees sign non-competes, definitely made me, I don't know if chuckle's the right word, but I definitely took note. So hope that's helpful. Update.